All rise. Please be seated. Thank you for coming back. Good to see everyone again. Good to see this is well attended today. This is our second oral argument session of the morning. This is case number 22-2589, Lusby versus State of Florida. Is the appellant ready to proceed?
Yes, Your Honor.
Would you like to reserve any time for rebuttal?
Please reserve 5 minutes of my time for rebuttal. May it please the court, my name is William Pinnell and I represent Joshua Lusby, the appellant in this case. As noted in the briefs, there's 2 issues related to the conviction and 2 issues related to the sentence. I'm going to focus primarily on issue 1. Of course, happy to answer any questions the court has on the other issues, and if time permits, I'll get to those. It's our position that Mr. Lusby, trial attorney, there was an actual conflict of interest existed when the trial attorney in this case represented both Mr. Lusby and his co-defendant, his girlfriend, Taquavia Goodman. And it's also our position that this is not a close call. This is Ethics 101. This is a serious conflict of interest that was so apparent that the state of Florida moved to conflict the lawyer off the court. And there was 2 hearings on that issue, and it's our position that after the actual conflict was established, that the trial court did not perform the appropriate or a sufficient colloquy to establish a knowing, intelligent, and voluntary waiver by Mr. Lusby.
Does it matter to us legally that this motion was advanced by the state? Is that a feature of our algorithm?
I don't think so. I think that any time it comes to the court's attention, the court has an independent obligation to investigate, and if it believes that there's an actual conflict of interest, to give the appropriate colloquy. And so the court was on notice here.
And maybe I misheard you, Mr. Pinnell, but I thought I heard you say this was so bad even the state moved. Is that a feature of this or not?
I don't know. I don't think it matters who did it. I think it's interesting. I think it shows how serious the conflict of interest was for the state to intervene. I think that's a unique fact of our case. I don't think it changes the analysis. I just point to it to show how serious the conflict was in this case. The state was so worried about it. They filed a motion, represented that they had gotten permission from the elected state attorney and maintained their position even after the court conducted the colloquy with Mr. Lusby and his co-defendant. So again, this is a serious conflict of interest.
There was a serious conflict of interest.
Sure.
If she was going to testify against him and they were going to share the same lawyer.
Sure.
Because as I understand it, she was in the process of evaluating a deal to testify against him in return for some leniency and sentencing, I suppose. But that just never happened. Correct?
There was a plea offer for a 3-year probationary sentence. She was facing a maximum of 30 years in prison. According to her colloquy and the lawyer's representation, the attorney gave her the pros and cons of accepting that plea deal. By definition, by advising her of the pros of that, of accepting the plea deal, she was acting against the interests of Mr. Lusby.
But they had the same lawyer at that time.
They did, and they maintained the same lawyer. And when Mr. Lusby went to trial, trial counsel continued to represent the co-defendant whose case remained pending. So it's our position that the conflict continued throughout the trial, where trial counsel had an incentive or an obligation under the rules, under Rule 4-1.7A of the rules regulating the Florida bar, to not implicate the co-defendant, the girlfriend. And I think the record reflects that. Although a feature of the state's case was that the .38 Super firearm was found, quote, at the defendant's apartment, the evidence actually established that this was the co-defendant's apartment that the defendant stayed at for some period of time. There was a dispute in the record about whether he lived there full-time or whether he only stayed there sometime. But what trial counsel didn't do is make any effort at trial, either through cross-examination, through evidence, and specifically during closing argument. She didn't make any argument that implicated Ms. Goodman, the co-defendant, because she wasn't permitted to by the rules of ethics.
Was Miss Goodman there at the time of the shooting?
Well, the answer is we don't know.
Is there any evidence in the record she was there?
The evidence was that the gun that the state alleges was involved in the firearm was found in her apartment on the top shelf. So I think it would be a fair argument for trial counsel to make in supporting a defense of Mr. Lusby to point to, because no one identified anyone.
I understand, Mr. Pennell, the fair argument.
Sure.
But is there any evidence in this record from any person? She was there. I saw her there. She was part of this. Any of that in this record?
There was evidence that she was nearby the scene shortly after the incident. There was no evidence putting her at the scene at the time of the shooting, but there was very limited evidence, if any. There was cell phone evidence that put Mr. Lusby in the area, but no one identified him at the scene. So I think the court's point is valid, but I think it applies to Mr. Lusby as well. So trial counsel has a duty here to raise reasonable doubt in any way possible for her client. And she was precluded from doing so due to her ethical responsibilities to the co-defendant. And again, when you look at the record, she mentions Miss Furlow Goodman's name a single time, did not mention a single time in opening, and only mentioned her name twice in the closing argument. Despite the fact that a feature of the closing argument was to refute the state's claim that it was Mr. Lusby because the gun was found in that apartment. But what the trial lawyer didn't do is say, or emphasize, or point to, or ever say, this is Miss Goodman's apartment. This is Miss Goodman's apartment, not Mr. Lusby's. It's just as likely that she was there at the shooting. And she wasn't allowed to do that because of the conflict.
Oh, I'm struggling to understand. This is the same lawyer that's representing both of them.
Yes.
And your argument is that there's evidence that this conflict persisted because he didn't aggressively defend him by pointing the finger at her.
Yes. And if you
But
look,
he already agreed, didn't, but the question today is, did your client agree to allow this to move forward, even though she was ready to rat him out?
so I think there's two parts. I think we have to show there's an effect. The conflict affected the representation, and that's what I'm talking about. Is she held back pointing to the girlfriend because she has an ethical obligation to her, and that was to the detriment of Mr. Lusby. And once that's established, we go into this colloquy that's required by the Supreme Court in the Larzavie case from 1996, and it says, was the defendant aware of the conflict of interest? This is what the judge, for the waiver to be valid, the record must show that the defendant was aware of the conflict of interest, that the defendant realized the conflict could affect the defense, and the defendant knew of the right to obtain other counsel. We would concede that the colloquy satisfied element number one, that the court made Mr. Lusby aware of a conflict. We would argue that issues 2 were not sufficiently part of the colloquy to make his waiver knowing, intelligent, and voluntary. Because if you look at the colloquy, and this is on page 1077 and 1078 of the record, the court says, and you understand that you have a right to conflict-free counsel. Yes. You understand what that means. Yes, sir. But the court does not explain what that means. Certainly doesn't tell him you can go hire another lawyer. He just says you have a right to conflict counsel. I would suggest that's conclusory.
But then the next sentence says, the court says, that meaning that conflict means that your attorney would not have anything but loyalty to your case is basically what it means. You understand that?
Yes, and so that I think that advises him that there's a conflict, but these 3 prongs are independent of each other and have to be proven by clear and convincing evidence.
I mean, it's a little thin, but the judge did say, you understand, your lawyer sitting next to you has to be loyal to you.
Right, but where I think the big flaw is the number 3, does he have a right to retain other counsel? That's never really said. It says you understand you have a right to conflict-free counsel, but they never tell him that he has the right to hire another attorney.
So, is it your suggestion that the trial judge has to use magic words in his colloquy in order to suffice?
I don't think there has to be magic words, but I don't think conclusory statements are sufficient on their own. I don't think to say you understand your rights without explaining the rights is sufficient. You know, I don't think you could say to a defendant, you understand you have rights under Miranda, you want to waive them, you got to read the 4 rights. So,
What if he entered the hypothetically, what if he said, have you discussed your Miranda rights with your lawyer? That's sufficient?
under this scenario, I would suggest no, because we're saying that the defense lawyer has a conflict and is not doing the ethically appropriate thing. So I don't think we should be accepting the representations of the attorney. I think the trial judge has an independent duty to do the colloquy. But
So let me make sure I have the forest, and then we'll get back to individual trees. You're conceding this is a waivable conflict.
I think under the rules, a waivable conflict.
Did your client also, in addition to the colloquy with the trial court, did your client also sign a written waiver?
He did.
And what is the relevance to our analysis of that written waiver in your view?
I don't think it has much relevance. I think again, it's conclusory. It says, this office has informed the undersigned count danger of the dangers and conflicts associated with representations to co-defendants, and the defendant has waived the objections and the potential conflicts. It doesn't tell us what the lawyer told him. Again, it's conclusory in nature. Again, under these scenarios, the case law we're relying on is the colloquy sufficient? So, but I don't think the waiver, I know the court said it was going to rely on the waiver or consider the waiver, but I think we'd be in a different position if the waiver said, I advised him if he didn't waive the conflict that my cross-examination of certain witnesses may be limited. My ability to argue that the girlfriend is another suspect would be limited. I think that waiver would be different, and I also think if the colloquy included that information, it would be different. Because number 2 is, did the defendant realize that the conflict could affect the defense? The judge talks a little bit about the plea and how that would be a conflict, but talks nothing about what would happen at trial. Doesn't say, Mr. Lusby, you understand that if your lawyer represents both of you, her cross-examination, the evidence she presents, and her closing argument may be limited by her duty to her other client. I think that's the information that needs to be given to Mr. Lusby before we have a knowing, intelligent, and voluntary waiver, not just a conclusion. Do you understand your rights? Do you understand you can have your own lawyer? I don't think we can presume, and I don't think the case law supports this, that a defendant understands the intricacies of a conflict of interest. And I would cite to the Lee case from the second DCA where they found it was a proper colloquy because the trial court properly explained how the conflict might affect the defense counsel's cross-examination. So we have a little more detailed colloquy in that case where the defendant is told, if you keep this lawyer, the cross-examination at your trial is going to be affected. We have nothing in this colloquy that gives the defendant any specific example of how trial counsel's performance could be limited. We just have the blanket, there's a conflict that it could affect the performance. But certainly, if you tell defendant, the conflict might affect her performance, he might waive it under those circumstances, but if he's told the cross-examination, the evidence presented, and the closing argument is going to be could be watered down, it's much more likely he's not going to waive the conflict.
What does performance mean?
I'm sorry?
You said it's undisputed that your client was told that the performance could be affected. What does that mean?
I think it's vague. I think it's vague. I don't think it tells I think it's got to be a knowing and intelligent and voluntarily waiver. And
but the performance, doesn't that presuppose, the word itself, that the performance of the lawyer is going to be affected by this? Isn't that not embedded in that term?
I want to make sure I understand where the word performance is used.
You just used it.
Okay. So maybe it was a poor example by myself, but I don't think the colloquy included that language. I don't think there was any reference to.
What did it include?
It included a reference that there would be a conflict if the lawyer decides that her co-defendant was going to testify against, his co-defendant was going to testify against Mr. Lusby. And the lawyer agreed if she did take the plea agreement, there would be a conflict. But there's no discussion of the conflict at trial and how that could affect, your words and my words, performance. It doesn't say this may affect your lawyer's performance at trial. It doesn't say it may affect the evidence presented. It doesn't say it may affect the cross-examination, and it may water down the closing argument. And under the facts of this case, where no one IDs the defendant at the scene, and there's multiple shooters, and the firearm that is found at the girlfriend's apartment is the main piece of evidence linking Mr. Lusby to this crime, it's unreasonable to believe that the lawyer, doing the best she could, would not point the finger in an effort to raise reasonable doubt at the co-defendant girlfriend. And that's the adverse effect of the conflict. And the deficiency in the waiver is the fact that the colloquy didn't sufficiently explain to Mr. Lusby what effect the conflict could have on his lawyer's performance. I reserve the rest of my time for rebuttal.
Thank you, Mr. Pinnell. On behalf of the state of Florida.
May it please the court. My name is Richard Pallas. I represent the state of Florida. Our position here is no fundamental error occurred with the scope of representation of these two co-defendants here, appellant and Ms. Furlow Goodman. Starting here, we have no actual conflict. It never rose from potential or possible conflict, and thus a waiver wouldn't be required.
Why did the state file the motion?
I believe the state filed the motion in abundance of caution, Your Honor, and if anything, I would see this potentially being more at issue with Ms. Furlow Goodman than that. Possibly saying, this is a probationary sentence for you, you're facing 30 years. If they summarize what the evidence is, or this is an overwhelming case against her, perhaps she's coming back with a Loeffler Art Alcorn claim or something later on a 3850. And if anything, this was to rectify the record, both in her case number as well as the defendant's case number here.
So your argument is foreseeably that the greater prejudice born of the conflict would inure to the co-defendant, not the appellant.
If there was any prejudice, possibly, Your Honor, I believe it would inure to her versus us.
Then how would you respond to your colleague's argument as to the manner in which reasonable doubt would be asserted by pointing to the co-defendant as opposed to the appellant as the one who committed the crime?
Your Honor, I would respond to that here, in whether or not we're at an actual conflict, it's that performance by the attorney was adversely affected by an actual conflict of interest. And our reasoning to go against that is, at a certain point, you can only say so many things to a jury. I would argue this isn't something that's clear from the face of the record. I think this is more of a situation as this court's Holcomb case out of 2020. In that case, they spoke of just having representation of multiple clients, some of which that actually testify at trial without more, does not rise from a potential to actual conflict. Here, one thing that's important is they were arguing that this gun was not actually the murder weapon whatsoever. Trial counsel brought in an expert who testified that this was more consistent with the .22 being used, and also brought in testimony that shells were being picked up closer to where the victim was shot versus at the tree line, which is, of course, the state's theory as to how this went along.
And that was a strategic decision of defense counsel.
That is correct, Your Honor. And, of course, here we're dealing with actual conflict of interest and not ineffective assistance of counsel claims. But here we're getting very close together, and I believe that once this appears that we're dealing with strategic decisions, of course, once you argue something's a strategic decision in the Rule 3850 context for ineffective assistance of counsel, it is said that if counsel looks at two reasonable strategies and chooses one over the other, we almost always defer to that unless this is something that reasonable counsel never would have done under the Sixth Amendment. And so I don't believe that, of course, in that situation and not what we have here, there would be no deficient performance or prejudice. So I cannot say we have something on the face of the record that counsel's performance was adversely affected. And to a certain degree, if we decide to point fingers at Ms. Furlow Goodman, whether I represent her or not, she wasn't charged with the homicide. She was charged with accomplice after the homicide. There was, of course, a video showing that something, potentially a sock, was found, and of course, the Taurus firearm that fired the 38 super cartridges that were, of course, linked to this particular crime scene by FDLE, as well as testimony from the medical examiner. While she's tied in under that accomplice theory, the state didn't decide to charge her as a principal here. She wasn't facing that same crime. And if this gets to the point where counsel decides to continuously say it might be this person, it might be this person, it might be this person, one of the adages is, pigs get fed, hogs get slaughtered here. We try to say we have reasonable doubt in too many ways. At a certain point, we say, then it sounds like you have nothing at all. And of course, the state's going to meet its burden in that situation. To go a little further here, I know with the Holcomb case, I need to stress, in Holcomb, two co-defendants testified. They entered pleas, and sentencing was actually set off afterwards. And this court, of course, held that even them just testifying without showing some sort of prejudice on the record did not get us there.
Did the co-defendant in this case testify against the appellant?
Your Honor, no. There was no testimony from her. I don't believe we even have any statements from her, except for, of course, the video that was getting it. What we do have statements are allegedly from the defendant here. We had the jailhouse informant, Mr. Turner, testify that he admitted that he shot, in the testimony says, that girl. And it had to do with, and of course we know that he had problems with one of the other potential victims there, said he was going to spray the place. And unfortunately, the tent was bullet ridden at the end of all of this. Here, I just do not see how this can at all rise to an adverse effect on the performance. But just to cover my bases real quick, Your Honors, to move on into the waiver itself, I believe that this waiver is sufficient. I don't think a judge needs to handhold just because it's an alleged that we need to have a hair trigger whenever a plea deal is asserted to a co-defendant to testify during co-representation. It does not mean that the defendant doesn't know what's going on here. I mean, trial counsel stated that I've gone over this with them. We have the written waiver. The state didn't just file this motion. The 3 pages of transcript, about 3 pages of transcript, I should say, before the actual colloquy went through, the state went into more detail as to why it thought that this was a problem. While I think that it's enough that trial counsel said, you understand what conflict counsel means, you're going to have someone who's only loyal to you, and then went into a couple other statements as to, you can actually have that particular counsel, these are the benefits for it, and this is why not having conflict-free counsel could be a problem. The ASA in this case, I know he wasn't the one at trial, but the one who filed this motion and who argued at this particular hearing stated why he thought this was a problem. And that is referenced, I think, in these colloquies. It's while this is a cold record, I think it's implied in the lines that we have here. And so taking the actual written waiver, taking this colloquy, and taking the state's statements on the record, I know the first DCA decision in Alexis was overturned by State v. Alexis, which is, of course, one of our guiding Florida Supreme Court cases in this, but it discussed how there was no waiver elsewhere in the record, showing that we can look at the entirety of this record. We're not just limited to the colloquy itself. And so, again, I believe that our colloquy, the written waiver, and the ASA statements on this actual Assistant State Attorney's statements. I don't mean to get lost in abbreviations here. But all of that together in this record, if for some reason this court was not convinced by this colloquy and thought that something out of the first DCA and Lee was more appropriate here, then I think that altogether would suffice. But a judge does not need to hold a defendant's hand here. If the judge starts saying, well, maybe your girlfriend did it, the judge is potentially drawing out what the strategy might be. Aside for filing a notice of alibi or, deciding to pursue insanity defenses and the like, the defense doesn't have to say what their strategy is going to be going in. In fact, sometimes the defense smartly changes its strategy halfway through the trial when they think they see how this is going. To say that the trial court needs to come up with every hypothetical defense here is essentially getting the trial court to move out of its impartial role as a neutral arbiter of this justice system, is asking him to basically be counsel plus, a new conflict.
Which could conflict out the court.
That is correct, Your Honor. And then in that case, this is going before another judge, and there's the possibility that reversible error is brought up here at one way or another because the judge inserted himself into the merits of these particular claims.
As it may pertain to opposing counsel's argument that there was prejudice suffered by the appellant by the failure to point the finger at the co-defendant, he references the firearm was found at the girlfriend's apartment. I think that was a phraseology or something close. Was there any evidence that the appellant also resided either entirely or at times at the apartment?
Your Honor, yes. There is evidence that, of course, I want to say the driver's license was found there, of course, with an address showing his mother's address, but also paperwork for, I believe, Department of Children and Families cases or something of the sort that pertained to only him, and, of course, T-shirts that appeared to be the same sort of style that he also wore. And, again, here, while we don't have any DNA linking him to the firearm or anything, he was there the day that this search warrant was seized. And of course, Detective Neal testified that we found things in this apartment that linked him to this apartment.
In terms of factual timing, both were charged together, co-defendants together, goes to trial, and in this case, the sentencing was on October of 2022. It was 4 or 5 months later that Furlow Goodman entered a plea. So her plea was after the trial had been conducted and the sentencing was concluded, correct?
That's my understanding, Your Honor. If that was mentioned offhand on the record, I must have missed that. I'm not familiar with anything extra record in this specific case.
I guess what I'm getting at, she did not enter a plea before trial or during trial,
That is correct, Your Honor.
after trial.
Yes, if we're at the sentencing was in October of 2022 and she did this after trial, and of course she did not testify at sentencing either in anything as an aggravator or something of the sort.
And let me piggyback to Judge Maytar's question. She ultimately received a probationary sentence.
That I am not certain of, Your Honor, without seeing that particular record, but it would not surprise me here, which seems like she got the same sentence that she would have gotten had she testified. And if that's the case here, she's not going to have any prejudice in the event that something comes up in an Alcorn-Lafler situation later. But I know that there were, of course, 4 issues total in this particular case. But if this court is satisfied with the state's answers in its briefs on issues 2, 3, and 4, and satisfied with my answers to the first case here, I will cede the rest of my time and ask that you affirm.
Thank you.
Thank you, Your Honor.
Mr. Pinnell, rebuttal. You've got about 4.5 minutes.
Thank you, Your Honor. May it please the court. Judge Maker's observation that the co-defendant didn't enter a plea until after Mr. Lusby's sentencing, I think is important. I think that shows the nature of the conflict, and because her case is still pending, trial counsel has a duty not to implicate her and put her in a worse position after Mr. Lusby's trial. So she can't point the finger at her or elicit any evidence that would implicate her, because that could result in then her being charged as a principal or result in them not giving her a favorable plea deal. So that
Is there any possibility that Mr. Lusby basically told his counsel, don't implicate her, don't implicate my girlfriend?
Certainly possible, but we're under Holcomb and the case law, we're required to establish some adverse effect on the representation, and I think the record establishes that. Then we get to the colloquy and whether the colloquy is sufficient. And it's our position the colloquy is not sufficient. And I don't think it's a fair characterization to say that we're asking the judge to hold the defendant's hand, I think you need to give a full colloquy that's not just conclusory. You need to tell them that there may be an impact of what is going to happen at trial. You certainly don't tell the defendant you can't point the finger you may not be able to point the finger at your girlfriend, but you do talk about cross-examination, evidence, and closing argument. And I want to point the court to the Holloway versus Arkansas case in the U.S. Supreme Court, and the important quote, I think, in a case of joint representation of conflicting interests, the evil it bears repeating is in what the advocate finds himself compelled to refrain from doing, not only at trial, but also as a possible pretrial, pre-negotiations, and in the sentencing process. So the conflict here is trial counsel had to refrain from doing certain things that would have benefited Mr. Lusby because of the conflict. And again, the 38 super firearm was the main link the state used to connect Mr. Lusby. It equally connected the girlfriend. To the extent it was a strategic decision to make some other argument, it's an unreasonable strategy decision when the 38 super is the essential piece of evidence relied on by the state. And the trial lawyer recognized this. If you look on pages 937, 938, and 941, Attorney Barker repeatedly highlighted the fact that the state needed to tie Lusby to the apartment so that they could link him to the firearm. What she doesn't do is say that also links Goodman to the firearm. So it's our position that there was not a sufficient colloquy, there was a very serious conflict, that there wasn't a knowing and intelligent waiver, and finally that this case is not like Holcomb, because this court in Holcomb said that the appellant in that case was not able to point to any adverse effect on the representation of his lawyer. We've pointed to some serious adverse effect in raising reasonable doubt on the behalf of Mr. Lusby. So it's our position that Holcomb is distinguishable, and in this case, the court should find that there's an actual conflict and not a knowing and intelligent and voluntary waiver. For that reason, we ask you to reverse the conviction and sentence.
Thank you. We will give counsel a moment to vacate their position, and then we'll ask the attorneys